G'day everybody and welcome back to week 6 of Evidence and Proof. I'm Anthony Marinac. This week we're going to look at the other two types of evidence, documentary and real evidence, having spent the last couple of weeks looking mainly at oral evidence. We're going to look at the rules that relate to the use of documents, and what we actually mean by documents, and we're going to look at some of the specific rules that relate to specific types of document. Once we've dealt with documents, we'll then switch over and look at real evidence. And you'll remember that we've already talked about the fact that real evidence includes exhibits, the demeanour of the witness in the courtroom, courtroom demonstrations, and views. So by the end of this week, we will have covered all of the basic rules around the use of all of the basic types of evidence in the courtroom. So let's start by having a look at documents. What is a document? We've already answered that question briefly in previous weeks by exploring the fact that a document is any medium on which information can be stored and later retrieved by somebody with the appropriate equipment. Documents aren't important for their own, they're not important on their own. They're important only for the information that they can actually convey. The important thing to note about documents, however, is that it's a functional definition. So they don't make a list of things that are documents. Well, in fact, in the legislation there is a list, but it's not a closed list. It's not as though if something's not on that list, it's not a document. Anything that can be used to store evidence is to store information is documentary evidence. And that makes sense because back when the Evidence Act was written in 1977, the concept of a floppy disk would have seemed like something out of the space age. Yet here we are less than 40 years later, and the concept of a floppy disk seems something like something you would hear about from the olden days. Technology advances so quickly. Concept of cloud computing, or the very notion of carrying around an iPad in years past would have been absolutely unfathomable. So the fact that the law has been cast in general terms, the fact that a document is anything that can store data and later produce it, rather than listing different types of document, is really quite sensible. So remember, the definition of a document is very broad, and it concentrates more on what the document does rather than what it is. So a piece of paper is a document, a cassette tape is a document, an old-fashioned record is a document, a label is a document, a computer disk is a document, a text message or an email is a document. In the coming weeks, in the next 3 weeks, we're going to spend a lot of time talking about a concept called hearsay. We're going to get ahead of ourselves just a little bit this week and point out that documents are all hearsay. Hearsay happens, you'll remember we've said previously, hearsay happens when you're not giving evidence about what you yourself observed. You're giving evidence about a statement that was made by somebody out of court prior to the court date. If you think about it, every document is a statement that was given by somebody, that was recorded by somebody in the document outside the court. So every document is a form of hearsay, which means every document is second best, because the question can always be asked, instead of getting this document and putting it in front of the court, why can't we just have the witness? Why can't we have the person who wrote the letter, or the person who sang the song, or the person who programmed the computer come along and give evidence, if we know that oral evidence is the gold standard? So at the moment, we'll talk more about hearsay in coming weeks, but at the moment I do want you to understand documents are hearsay, and I do want you to understand that in many ways that makes them second best compared to the gold standard oral evidence. Why would you use them then? What's the point of documents? Well, they have some pros and cons. The best thing about documents is that they're usually much more precise and much more carefully expressed than oral evidence. There's no ums and ahs, they use full sentences. Everything is expressed in a way that just would translate beautifully into quoted paragraphs of the judge's final judgment. Furthermore, they can be made at the time of the incident. so you don't have problems associated with the limitations of memory, the limits of memory, because a document that's made at the time of the event is still going to look exactly the same in most cases when you come to the courtroom. There are some negatives though. Wouldn't it be a bit unfair if all of your witnesses turn up to give oral evidence, but all of the other side's witnesses just wrote letters, so that they had a chance to think carefully, to sit down and take advice, to phrase everything just right, but your witnesses had to make it up in the witness box? That wouldn't be fair. Why should a person providing documentary evidence have that advantage? Second, however, and most important, you can't cross-examine a document. It says what it says. You can interpret it one way or interpret it another, but you can't ask a document any further questions. You can't get a document to clarify itself, and you can't get a document to fool itself into showing that it's quite unreliable. One of the fundamental rights of a litigant in our system of law is the right to cross-examine the evidence of the side who's against you. You can't do that with a document, and that on its own makes documents a second best form of evidence. So what are the rules associated with documents? Well, the rules used to be, we're going to start with the common law and then look at some of the statutory rules. The rules used to be that to be used, a document had to fall under one of the hearsay exceptions. This will make a lot more sense if you read the same slide in about 3 weeks' time. What you'll find when we talk about hearsay is that there are a bunch of exceptions where hearsay evidence is allowed to be used. Well, we know that documents are hearsay because we discussed that a minute or so ago. If documents are hearsay, then it makes sense that they can only be used if they meet one of those hearsay exceptions. In most cases, the original document was usually required to be put into court. That's not really the case anymore, because the concept of an original document doesn't really make any sense if, for instance, the document is now stored on a computer disk. The fact that the print button was first pressed on a particular day doesn't make that printed version of the document any more authentic than a later print. Even once a document was admitted, it could only be used in a way that was consistent with the hearsay rule, and the document had to be authenticated by being adopted by a person. So some witness had to bring the document into court and say, this document is my phone records for the month of July. Now the interesting thing is that the witness who comes in and authenticates the document doesn't have the right to just answer that question about the document. So if the witness comes in to authenticate the document, you can hit them up with cross-examination about the contents of the document anyway, which begs the question, why bother with the document? Why not just bring the witness in to give their evidence? Now the common law is the starting point, but the common law has moved on a little bit, and we now have a bunch of statutory rules in the Evidence Act that have modified the common law. The basic rule now, the rule that you'll be expected to know for civil trials, is in section 92 of the Evidence Act. Documents can be admitted if one of two conditions are met. First, the person who made the document must be known and must be available to give evidence. So if we know who made the document and we intend to call them, or they're available to be called, well then the document will be admitted, because there's still the capacity to cross-examine. We can't cross-examine the document, but we can cross-examine the person who made it. Alternatively, the document must relate to an undertaking and must have been made in the course of that undertaking by an appropriate person. So imagine that you're part of an organisation, and the governing body of that organisation has regular meetings and produces minutes. The minutes of those meetings are likely to be admissible as evidence because the document relates to an undertaking and was made in the course of that undertaking by an appropriate person. An even more simple example is a receipt that you receive when you buy something. Okay, it's a document that relates to an undertaking, that is, the purchase of a product, and it was made in the course of that undertaking by an appropriate person. So that makes sense. For criminal trials, similar rules apply. but the document has to relate to a trade or business and not just an undertaking. So the rules are a little bit tighter for criminal cases, but that's pretty reasonable, because in criminal cases, of course, the accused person is exposed to the potential for criminal sanctions. Now, those are the basic rules. On top of that, there are a bunch of specific rules for specific types of document. Photographs have to be authenticated by the photographer. So if a photograph purports to be of a particular person or a particular event, you have to have the photographer available to say, I took that photograph. The only exception is if the photograph was taken automatically by, for instance, a security camera or a red light camera, in which case somebody has to be available to explain the operation of the device and where and how it was positioned so that the photograph can be authenticated. Second, photographs are notoriously capable of being toyed with and amended so that what you actually see is not what you appear to see. If a photograph has been retouched, that is, if the image has been modified in any way, it's not likely to be admissible in evidence. Now, that's become a real issue in the Photoshop era, because just about everybody modifies just about every photograph they ever take, and everyone is carrying a camera everywhere that they go, because we've all got smartphones and they can all take photographs. So the veracity of photographs, the usefulness of photographs as evidence, is becoming really tested in the Photoshop era, because you just can't be certain that what you're seeing in the photo is the same as what was actually seen at the time of the event. The other problem with photographs is that they're sometimes used simply for the purpose of upsetting people. If you're trying to get the maximum possible penalty for somebody who's committed a violent crime upon another person, one great way to do it is to stick a whole bunch of photographs of graphic injuries of victims in front of the decision makers and hope that that has an emotional impact. Well, we're not supposed to sentence people on the basis of emotion. We're not supposed to reach verdicts on the basis of emotion. It's meant to be a logical exercise. So photographs can be really open to abuse as a form of evidence. So generally speaking, it can actually be quite difficult to get photographs admitted to evidence. Next, audio recordings. Audio recordings are kind of interesting because you would tend to think that a transcript of an audio recording is going to be useful. In fact, if the audio recording can be played intelligibly to the court, then it should be played to the court, and the playing of the audio will be the way that it becomes evidence. The transcript is only admissible when the audio would make no sense. Now, there's a case listed there, Butera and the DPP, which is a great example. This was a case that involved an organised drug smuggling ring, and the conversations that were recorded between the alleged perpetrators, those conversations were not conducted in English, and so a translated transcript of the conversations was placed before the court, and that was sensible because the members of the court spoke English, and English was not the language that was being used during the tape. Had the people in the tape been speaking English, the transcript wouldn't have been used, because we're not interested in what the transcription service says is on the tape. We're interested in what we hear in the court when the tape is played. Next, let's talk about computer-generated documents. On the slide there, you'll see a Radio Shack TRS-80 computer, and I've put that in there because that was actually the first type of computer I ever owned. The memory on that computer, the RAM on that computer, was 4 kilobytes. Now, for under $1,000 these days, you can buy a computer which has 4 gigabytes of RAM, which means that in the space of about 30 years, the computers have become 1 million times more powerful. That's what the law has had to try and keep up with in the last 30 years. Computer-generated documents have gone from being punched cards that have to be fed into other computers in order to make sense, through to being the mass-produced, very effective laser printed documents that we see every single day. How do we know that something that's been printed out from a computer is reliable as evidence? The way the statute deals with this is to require certification by an appropriate person to authenticate that the document is a faithful reproduction of whatever was on the computer. Carlowan and Cohen is not exactly an authority for this proposition. It's only a district court case and it only occurred last year, but it's an example of the rule in action. Carlowan and Cohen was a case where there was a traffic related offence that was being contested by the motorist, and what they were contesting was that they hadn't received the notice appropriately. It was shown that on the basis of computer records held by police, they had in fact had the notice issued to them, and those computer records were certified by the appropriate person within Queensland Police who investigated the databases, and the courts accepted those print-offs as being appropriate evidence. So if you're going to use evidence that's computer based, it needs to be certified in order to be authenticated. There's two types of computer evidence, however, that are not hearsay. They're immediate evidence and they don't have to meet all the rest of these rules. First is where the computer is just used as a calculating device. So if you use a computer to take a whole bunch of data and turn them into a graph, then the graph itself is not hearsay, provided you can explain how you generated it. Second, if the computer's recording data that was not generated by a human being, it's not hearsay. So for instance, if you have a scientific instrument that is recording data that cannot be perceived by human beings, then the data that is recorded by those is not regarded as hearsay. However, you're still going to have an expert available to explain what processes were used to enable the computer to collect and then interpret that data. Next type of document we need to talk about is business records. If you think about corporations law or contract law or tax law, they're all about documents, and if you had to go through difficult processes to authenticate every single document that was going to be put in front of the court, the whole system would grind to a halt. So for business records, which are books of account, that is the accounting books of a business, they can be admitted to evidence automatically without any need to get the accountant along to certify that those books were actually prepared properly. The reason for this is we already have auditing requirements. We already have people who are qualified auditors signing off that those books were kept properly. We have Australian New Zealand standards for auditing which those audited books have to meet. There's really nothing added to the court's knowledge about those documents by forcing somebody to come along and authenticate them. Next, we'll talk briefly about documents which are the substance of the dispute. We've already talked about this once before and there's not a great deal to add. Some documents are central to a dispute. You can't have a contract case without talking about the contract. You can't have a probate case without talking about the will. In those cases, the documents are not hearsay. The documents are actually the substance of the dispute and the documents will be admitted to evidence. The final sort of documentary evidence we need to talk about is DNA. DNA has completely changed the world as far as the criminal law in particular goes, and also it's changed certain aspects of the law in relation to paternity and child-related matters. DNA is also a very highly specialised scientific field. It's not as though you can go down to the local corner shop and get a DNA test done. There are a limited number of people that the court has authenticated, or that the statute has allowed to be authenticated as DNA analysts. DNA analysts can provide a certificate which outlines the results of any DNA testing which they have done. Theoretically, if a party seeks to rely on one of those certificates, the analyst has got to be available to give evidence. But realistically, because only certified analysts are entitled to give DNA evidence, most of the time the DNA certificate is going to be taken at face value. So that's documentary evidence. We want to turn now to the third type of evidence, which is real evidence. We've already talked about the fact that there are various types of real evidence, and what unites them all is that it is something that can be seen or experienced directly by the court. Having said that, real evidence still requires oral evidence in order to put it into context. Let's imagine, for instance, that you have a criminal case that's based upon two people who were involved in a knife fight, and someone brings in a knife as an exhibit and lays it on the table. What does it tell you? Not much. It doesn't tell you who was holding the knife. It doesn't tell you what was done with it. It doesn't tell you whose bloodstains are still on the knife. It doesn't tell you what the knife is made of. It doesn't tell you anything about the story that brought that knife from the night in question into the court. Real evidence needs to be presented and clarified by oral evidence, or it just makes no sense. Now that leads to an interesting question. If the real evidence requires oral evidence in order to make it sensible, why not just use the oral evidence? This is a question that you're always going to have to ask yourself in applying real evidence. Does the real evidence add anything? Or are you just making the case more interesting for the court? If the real evidence is just theatre, please, for me, don't do it. If it offers a perspective and a context that you can't get from the oral evidence alone, then you might be justified in using real evidence. Let's look at the different types of real evidence. We'll start with the witness in the courtroom. The judge and the jury are not going to be able to help the fact that they will apply their own experience as human beings to the interpretation of the witness and the interpretation of the defendant as they sit there in the courtroom. In fact, that's probably why we have juries. We ask them to bring their experience as citizens and normal human beings into the courtroom when they're making decisions. They will look at a witness and they will try to work out whether the witness is telling them the truth. They will look at body language. They will look at the way the witness is dressed, whether the witness is looking around to try and seek reassurance from other people in the court. These things they are allowed to do. In addition to that, they may get some more specific information by looking at the witness. Does the witness have a strong command of English? That might make a difference if we're talking about an oral contract that was being conducted between two people. If a witness is supposed to have agreed to quite a complicated promise that was only ever agreed orally, and they get up in front of the court and they have difficulty understanding a cross-examiner's questions which are presented to them in English, that's going to leave the judge or the jury to make certain conclusions about whether they're likely to have entered into the contract. Does a witness have a physical disability? A physical disability might affect, for instance, their ability to have done the things that they are supposed to have done in order to commit the crime. Last week you were asked to watch a scene from To Kill a Mockingbird, and in the course of that scene it became clear that the defendant, Tom Robinson, did not have the use of his left arm. And that was demonstrated in the courtroom. That was a piece of real evidence. The jury could see for themselves that the witness had a physical disability, and that physical disability impacted on the chance that he was likely to have committed the crime. All of these things are perfectly normal and perfectly acceptable, so the demeanour of the witness can be a key factor in terms of real evidence. This, of course, is yet another reason why you should properly proof the witness before they go into the court, so that they can be able to give the best account of themselves in a physical sense, as well as in terms of the actual oral evidence that they give. Next type of real evidence we want to talk about is exhibits. Exhibits are things that are brought into the court. Probably one of the most famous exhibits is the glove that was brought in during the trial of O.J. Simpson, and the glove didn't fit. And we'll talk more about that in a few moments when we talk about courtroom demonstrations. Most of you who've done criminal law will remember the case of Armory and Della Marie. This was the famous case where the chimney sweep's assistant was sweeping the chimney and found a jewel, which he took to the nearest jeweller's to have it valued. The jewellers took one look at it, took it out the back, removed all of the precious gems and replaced them with rubbish gems, and gave the chimney sweep a very low estimate of the value of the jewel. The chimney sweep said, "Nope, I'd like to have my jewels back, please," and they refused to give them to him. The case stands as authority that the finder of a lost piece of property is able to assert possession against everybody except the true owner. But for our purpose, the interesting thing about Armory and Della Marie was that when they were assessing the damages, the judge actually had the jewel, the setting, produced in the court, brought the setting into the court. The stones were not available because the jewellers had already set the stones into other pieces. So the judge said, in that case, I'm going to assess evidence by taking the most precious stones that could fit this setting, and I'm going to assess the value of the jewel as though it was at the most precious that it could have been, consistent with the other evidence. So in other words, where there's any benefit of the doubt, it's going to the guy who hasn't done the wrong thing. That was a form of real evidence because the exhibit was brought into the court and was examined by the courtroom. Kozel and the Queen is an even more dramatic example. This was a case that involved a pistol, and the question of whether the pistol was fired deliberately or whether it was fired accidentally when the victim tried to knock it out of the perpetrator's hand. It was brought in, and the pistol was given to the jury, and the jury were encouraged to play with the pistol to see how much of a knock would be required in order to make the pistol discharge. Obviously the pistol wasn't loaded at the time, but they were encouraged to see how much of a knock would make the hammer fall onto the firing pin and discharge the weapon. Kozel and the Queen crossed the line, in my view, into experimentation, because they weren't just looking at the exhibit, they were actually tinkering with it and experimenting with it. And that's, in that case, the court is generating its own evidence instead of relying on the lawyers to bring the evidence in front of the court. Unfortunately, the High Court disagreed with me, and they haven't gotten around to giving me my seat on the High Court just yet. What they said was that in Kozel and the Queen, when they were playing around with the pistol, all they were really doing was taking an opportunity to examine it more closely. I think there's a very, very fine line there, and the High Court probably fell on the wrong side of it. The bottom line is that when an exhibit is brought into court, you're allowed to look at it and learn from it, but the court is not entitled to conduct an experiment with the exhibit. If the other side's bringing in exhibits, you need to be very careful to make sure that your case is not subject to the outcome of some experiment that you don't have any control over. We talked a few minutes ago about documents. Sometimes it's really hard to tell if something's a document or an exhibit. My favourite example is a t-shirt with an offensive slogan. Let's say the t-shirt has a racist slogan, and the wearer of the t-shirt has been pulled in on the basis of the suggestion that they were trying to incite criminal activity by wearing this t-shirt with a racist slogan. And the t-shirt gets produced in court. Is it a document or is it an exhibit? On the one hand, it's a thing that the court's being shown. On the other hand, it clearly carries data in the same way that a written document would. It's just that this document happens to be made out of cloth and in a t-shirt shape. So it could be a document, and it could be a thing, could be an exhibit. And try as I might, I can't find any clear-cut rule which differentiates between the two. What seems to be the case is that if you're bringing something into court in order to rely on the data that it contains, it's probably a document. On the other hand, if you're bringing something into court in order to rely on it for what it is itself, then it's probably not. So if that same offensive t-shirt was brought into court in a case that had nothing to do with what was written on the t-shirt, but it was a key part of identifying the witness who ran away after a crime was committed, it's probably an exhibit. because we're not really worried about what the data is that's contained in the writing on the t-shirt. We're worried about the t-shirt as an item. All I'm really asking for the purpose of this course is that you understand that actually it can be kind of difficult sometimes to tell whether something is an exhibit or whether it's a document. And as we're learning this week, that can completely change the rules which will apply in terms of admitting the item into evidence. The third type of real evidence we can talk about is courtroom demonstrations, and I've already given you all the drum on courtroom demonstrations. You already know I hate them. You'll remember the story that we talked about last time with the prosecutor demonstrating how long it would take to stab somebody 93 times, and the fact that, to me, it was just cheap courtroom drama. Well, a few slides ago we had a picture of O.J. Simpson. For those of you who are too young, O.J. Simpson was a football hero in the United States of America who was accused of killing his partner, and it became the most famous and celebrated trial of the criminal trial of the 1990s. It looked like they had him stone cold guilty. It looked like there was going to be no way that O.J. Simpson would get a not guilty verdict, until the prosecutor was stupid enough to bring into the court an exhibit in the form of a pair of gloves. Not only was he stupid enough to bring the exhibit into the court, he then decided to conduct a courtroom demonstration. He gave the gloves to Simpson and said, "Put them on." What a dumb thing to do, because even if the gloves fit Simpson, it doesn't actually prove very much. All that it proves was that if those gloves were worn by the perpetrator of the crime had the same sized hands as O.J. Simpson, and let's face it, the size of hands is across a pretty narrow range across all of humanity. So I really wonder what the prosecutor was hoping to prove. In fact, what happened was, when Simpson tried the gloves on, they were way too small for him. And so the courtroom demonstration completely backfired, because if the prosecution was saying these gloves were worn by the murderer and the gloves didn't fit Simpson, it was very easy to conclude that Simpson mustn't have been the murderer. Simpson's lawyer, a bloke named Johnny Cochran, jumped straight up to his feet and uttered his line which would go down in legal history: "If it does not fit, you must acquit." And the jury did. Hundreds of hours of testimony, thousands of pages of testimony went straight down the drain in those 2 seconds when the glove didn't fit O.J. Simpson. Courtroom demonstrations can go badly, badly wrong. A case that I'm asking you to read this week is the case of Li Shuling and the Queen, which is a Privy Council case that came to the Privy Council from Hong Kong, when Hong Kong still belonged to the Commonwealth rather than to China. In this case, the accused had confessed to murdering his partner, and the police asked him to take them back to the scene of the murder and to reenact the murder on video. So to show on video what he had done in the course of committing that crime. Essentially, the court determined that this was a videotaped confession, that the demonstration that the accused was giving was equivalent to confessing the crime, because he was not doing it involuntarily. He was doing it in order to cooperate with police and in order to provide information which he knew was very likely to turn up in court. So the court decided that was okay. And that makes sense. In fact, that's the only sort of courtroom demonstration that really does make sense. If you ask a witness, "Can you show me where your hands were at the time that you say you were grabbed from behind?" the witness could position themselves into the same position they say they were in at the time of the offence. That's a courtroom demonstration, but it's a courtroom demonstration that really exists only in order to make sense of their oral evidence. That sort of thing is fine, but please, let's all spare each other the cheap courtroom drama. Finally, we need to talk about views. We've already said that a view occurs when the court goes on an excursion. So the court travels away from the courtroom and conducts an actual in location examination of the scene of a crime. We've already spoken about the fact that at common law, the purpose of a view is not to generate new evidence. The purpose of a view is to enable the court to understand the evidence that it has already had in front of it. Under the Uniform Evidence Acts, however, so in the Commonwealth jurisdiction, not the Queensland jurisdiction, views are a form of evidence. They're treated like a courtroom demonstration that just doesn't happen inside the courtroom. One of the most famous views of recent years was an informal view that was conducted by two members of the jury in the gang rape case of a number of accused, including infamously an accused person named Bilal Scaff. He was part of a group of youths who were accused of gang raping a number of women in Sydney. He was later sentenced to 55 years in prison. The first trial was actually aborted because during a gap in the trial process, the jury foreman and another of the jurors actually went out to the site where the offences were alleged to have been committed, and they did so in order to check out the light, in order to see whether the evidence that they were hearing about the state of the light in the park was actually the case when they went and had a look themselves. What you can see is that by doing that, they'd exposed themselves to information which was not evidence, because the court had never had an opportunity to consider whether it should be admitted to evidence. Neither of the parties had had an opportunity to decide whether it should be put into evidence. The jurors didn't have the lawyers didn't have an opportunity to cross-examine anybody about those observations. It was a big mistake, and it resulted in the first trial being aborted and everybody having to start again. It just goes to show that views are fraught with danger, but sometimes the court will decide that the only way to properly understand the evidence that it's been given is to get up for itself and take a look. The likelihood is that you will go through your entire career without coming ever close to a view, but you need to know that they're out there. So there we have it, documents and real evidence. This week in the movies, we're going to look at a movie called The Insider. It's a Russell Crowe movie based on a real story, based on the story of Jeff Wiggand, who really exploded the tobacco company's ability in the United States of America to pretend that they didn't know that the cigarettes that they were producing were creating nicotine addiction. I hope you enjoy the scene from The Insider, and that the questions that follow it in the notes give you some great food for thought, and I'll look forward to talking to you again next week when we'll start talking about Hearsay.